Recording software. Okay, and we're back. Had to restart the recording software. So, um, Justice Anton Scalia held that the enforcement of the restraining order was not mandatory under Colorado law. Were a mandate for enforcement exists, it would not create an individual right to enforcement that could be considered a protected entitlement under the precedent of Board of yada yada yada. Such entitlement would have
So this is a case of whether the police are required to enforce a restraining order.
Yeah, and the thing is a lot of people, myself included, believe that if the police do not protect you, there functionally is no monetary or criminal um, penalties for the police. And functionally speaking, that means that the police have no duty to protect you. Right? They have a duty on paper, right? But if they don't, there's no consequences, virtually no consequences. If the government does not protect you, and if the government and the agents of the government do not protect you, if they decline to protect you or they decline to enforce, then the government will not hold itself accountable for said lack of enforcement. Right? So in my personal opinion, the duty to protect, right, that we think the police are supposed to be about, it doesn't actually exist. It only exists on paper. What do you think?
You know, as you describe it, it seems like that's logical. I would
Yeah.
disagree that that's how it should be.
Oh no, it shouldn't be like
If
that at all.
if right, if those are the facts as they are, I believe this is one of the many reforms in policing that need to be addressed.
Okay. Okay. Now, my personal opinion. Oh, are you still there? Oh, I
I
think.
am. I just needed to clear my room.
Okay, no problem. Um, in my personal opinion, how does it work? So to me personally, I believe that obviously with this case is pretty much an overt, right? This paragraph like that I just posted, um, is it's just a very long roundabout way of saying that, hey, guess what, the police have no duty to protect you. Who says? The highest court, the law of the land. um but practically speaking, I'm talking simply in terms of practicability, right? The police population is less than 1% of the U.S. population. The police are not omnipotent, they're not omniscient, and they're not omnipresent, right? So the police practically, in practical terms, um, simply cannot defend an individual or a group in such in a way that they can defend themselves. I think that's a logical argument.
Sure.
So, um, I guess my point is that I believe that firearms and arms and knives, guns, whatever, the tools of personal self defense do exist, can exist, and should exist, and that the individual and private groups, if so should they wish, should have access to the means of self-defense. And we'll get into self-defense later on down the line, but ultimately that's what it means to me as far as the Second Amendment. However, I agree that arms should not exist in mental health care facilities and prisons. However, I believe in those facilities that the people who are interned, people who are in custody, do not have the responsibility to protect themselves. They being in the custody of the government, or whether it's the federal government or all of its derivatives, means that the federal government or whatever government is liable for your personal defense, right? So if they deny you access to arms, um, then they should be held liable to defending you. That's my personal opinion. How do you feel about that?
I agree with you 100%.
Cool. Um, so even when it comes to prisons, even when it comes to the absolute worst of us, right? Prisoners, right? Prisons and prisoners should have means and tools and abilities, or steps should be taken to help prisoners be protected from other prisoners
Right.
or themselves. Um, okay. So okay. What are we at? We're at 5 minutes. Okay. Um, now the next thing I want to talk about is where do you think the limits of age come into the Second Amendment?
I guess broadly speaking, the Constitution applies primarily to adults as full citizens, where minors are still in the care of their parents. It's not that there are aspects of the Constitution that don't apply to minors, but the fact that a law exists that says a minor cannot be armed at all. I mean, I don't think that there is one. I think that hunting permissions are ubiquitous, but I think that a law that restricts minors from being armed is constitutional, where the exact same law applied to an adult would not be.
It's tricky with children and I'm not even talking about children and guns, but children and the means of self defense, the children and the means of violence, the tools of violence. Because on one hand, these are children, these are inexperienced, unknowledgeable human beings. But on the other hand, these are children who are physically weaker, and I think we can agree that the statement is correct: is who are simply more vulnerable than adults.
Sure.
So it's a tricky one, and I think that my mind has not been made up as far as children and firearms are. I'm probably of the opinion. I think I stand pretty firm that children can possess, not own, but possess any firearm whatsoever in the company of their parents, in the endorsement of their parents. How do you feel about that?
Generally, I would agree. But especially if we're talking about ownership, um, that does not extend to use and carrying in public or that type of thing. I think that ownership within the letter of the law, if a weapon is legal and it is legally allowed for the parents to consent to that their minor going to the range or hunting or doing whatever with it within their presence, I think that that is fine. I don't think that your parents endorsement to go out and carry that weapon in violation of a law, I don't think
Uh,
that supports anything.
I misspoke. What I mean is that the child can possess, physically control, not own, but can possess, right, in their hands any weapon whatsoever, as long as they are in the company and the endorsement of their parents, right? So under the supervision of their parents, or
So you're generally talking about hunting and sport, or
I mean, if a child wanted to
are
come
you
to a
also
open,
thinking of a self-defense scenario where you have a home invasion and the
yeah,
parents hand their kid a gun
yeah,
and tell the
yeah,
kid to use it?
open carry protest, something
I'm
like that.
okay with all of that.
Cool.
I
Uh,
if that being well, open carry protests will all depend on the laws of open carry and what limitations they are. But barring specific laws, I'm 100% agreement with you that parents can make that decision
right. Um,
appropriately.
so for the issue of Kyle Rittenhouse, this is my personal opinion, is that I think I think that the law he's being charged under. I don't know if the charges are going to stick because I took a look at that law, and it has a lot of ifs and ors and a lot of this and that. So I don't know if that particular charge is going to stick, but I think that the law in itself is unconstitutional and shouldn't exist, and he shouldn't be charged with it. That's my personal opinion. I think if I was going to be very pro safety, that the law should be for 16-year-olds and under. But I'm not arguing the law. I'm not because clearly there is a statute's wonky and has a lot of ifs and ors. But that's if I was God.
I could tell you that I would agree with you, or I would accept that argument. I think that that argument should be debated in good faith in a lawsuit or in the Wisconsin legislature. They should be discussing whether or not this is a constitutional law or not. At the point in time that this event happened, it was the law on the books, and he is subject to that law. But I can't say that you are 100% wrong.
Okay,
And I think that if they made that decision to change the law for that for unconstitutional purposes, I think I would get behind that.
appreciate that. Cool. Um, so the next thing, firearms. The Second Amendment as it applies to licensure. How do you feel about that?
I don't think the Second Amendment has anything that impacts licensure requirements. I think that if purchasing a firearm requires a license, I don't think it's an infringement on somebody's ability or right to be armed.
Okay.
I think that the strength of those requirements should depend on the type of gun. I am generally okay with basic hunter safety and registration for hunting rifles and you know home protection shotguns, revolvers, and handguns in general. I am certainly okay with there being very little impediment to owning and possessing one of those. I think that the bare minimum criminal background check, to make sure a person is actually not prohibited under some law. I think that the bare minimum check should be there for standard weapons that would allow a person to execute their Second Amendment right. I think that when you get into more complicated weapons, weapons that are geared more towards specific purposes, sportsmen, the excitement of the weapon, or if they're really just designed for human killing. I think there's a number of different things that put different classes of weapons at different regulatory requirements. And I have no problem with a stepped up regulatory requirement depending on the type of weapon we're talking about.
Okay. Okay. I personally don't believe in licensure for a Second Amendment. I feel that turns a right into a privilege, and I think we're just going to fundamentally disagree on that. But that's my personal opinion. I'm not going to say I respect because that would be a lie. I don't respect your opinion, but I tolerate your opinion, right?
Yes, you also have to note that my opinion is the same opinion that is currently in judicial precedent. That is currently the state of the law in the United States.
100%.
So it's not just a disagreement, it's the state of the law.
100%. 100%. It's just I tolerate your opinion. I tolerate obviously I'm not out shooting up a courthouse, right? So I tolerate the law as it is, and even though if I disagree with it. So I think we can agree on that.
And I just want to sort of add a real quick point because I think it may be interesting in the context. I think that opinions like yours should be part of the debate. I think that when Congress, either at the state level or the federal level, are debating different laws, I think that is the kind of argument that we should be having, should be discussing between the two sides. But in order to do that, we have to clear out all of the nonsensical arguments that tend to cloud the waters. And I think that a huge part of finding a common ground are these certain kind of false narratives that can skew the whole discussion.
How do you feel about machine guns and RPGs, hand grenades, dynamite, C4, that kind of stuff?
I think that those all fit into the stepped up regulatory. I think that a number of those should not be for public use at all. I think that some of them should have licenses. Say you own a gun range.
Okay.
You know, if you own a gun range and you have a license to have a fully automatic machine gun for use at the property, I think that that's perfectly fine. I think that a gun range is the ideal place for gun enthusiasts to go and fire off something like a fully automatic uh, machine gun.
Okay.
Um, I don't think that extends to RPGs and further on up, but I do believe that it's all part of a stepped up responsibility basis, especially when it comes to having liability insurance and that type of thing. Like the requirements become stronger as you
So,
go in more powerful weapons.
so how do you feel about this? Let's say we could agree to disagree. Try and find a compromise here. How about how do you feel about national reciprocity, concealed carry reciprocity?
Can you describe what you mean?
Concealed carry reciprocity was the idea or a law that was trying to be pushed was that a person who is licensed or endorsed um, by the by one state or one county or one city will be nationally endorsed, and meaning that so if I'm licensed in New York to carry, and I go down to where is it, New Jersey, or and I get stopped and searched, and they find a gun on me, but I show them my concealed carry card for New York. Um, New Jersey can't charge me. They can't charge me with with possession of a weapon. New Jersey has to respect New York's concealed carry law, and vice versa, right? So somebody who's licensed in New Jersey
I get it.
goes up to New York. So that's kind of that's kind of national reciprocity. Now, and this is my personal.
My view is that it is not a federal issue. It's a state by state issue. I think if New York and New Jersey have a reciprocity agreement, it should hold. If they do not, it should not. You are liable. You are liable for the laws of the state in which you're in. And in all circumstances, there are no situations where your home state laws being different from the state that you commit a potential crime in, that your home state laws become a defense.
Okay.
And I don't think this is one either.
Okay. Um, and so carrying by that, would you say, or you agree with possession laws? Maybe if a person is caught with a firearm, concealed carrying a firearm without a license, um, in the while out and about, do you think that should be a crime?
If the law requires them to be licensed to concealed carry and they are not licensed to be concealed carry in that state, it's a crime.
Okay. Okay. And how do you feel about felons? People, the whole prohibited possessor thing. That felons should not be able
I
to.
think that there may be specific incidents that have to be questioned a little bit more deeply, but if as a general term, I believe that once somebody has paid their debt to society for their crime, that crime is a thing of the past. Now, if the crime happened to be a violent crime and a specific judge orders the continuation, I don't know. I'd have to really be subject to specific. But if we're going to talk at a high level, I think that once you have served your time, any and all restrictions that are in effect from your crime are gone.
So it has so okay, okay. I think we can agree on that. We're at 18 19 minutes for this one, so I'm gonna stop it here and then restart. Okay.